Today, Claire and I are going to be talking to you about data protection generally. But if we can have the next slide, Amy, I can show you what we're talking about. So we're going to cover data security in online services, photographs and videos of pupils, subject access requests and exam grades, documentation and accountability, staff training and international data transfers. And these are, as you will know, data protection is a huge subject, and we could talk at you for a week probably if we wanted to on all the aspects of data protection. But we've picked out some of the key issues that we're being asked by schools at the moment. So these are sort of some of the key questions that we're getting so that we can hopefully answer some of your most asked queries. Could I have the next slide, please, Amy? Thank you. So online services and data protection. Obviously, if you're using an online service that requires you to use some form of personal data, such as Zoom or Teams or whatever it is you're using, the requirement to make sure that that is secure is the same as the requirement to make sure that any application or process that you're using is secure. So the requirement to keep data secure is the same regardless of what platform or operation that you're using. And we're talking here about online services because, without wishing to state the obvious, we're all using online services a lot more and have done since we started working from home, and particularly in schools where you've seen the benefits of using things like Teams, using Google Meet or whatever it is that you're using in order to deliver lessons. That can actually be quite helpful, particularly if you've got cohorts who are having to isolate. So taking it back to the essentials, what are the key things that you need to think about in terms of security? And as I said, this is the same whatever you're doing with personal data, but particularly in relation to online services, because it tends to get overlooked. You need to have in place appropriate technical measures. So those are your, I like to think about it as it's the sort of hardware, software type measures. So what have you got in place to make sure that only the right people are accessing the right information? Who has access to it? What are they doing with it? How are they using it? And then there's the organisational measures, and that's more around your people measures. So do you give appropriate training as to how to use these features? Have you got all the right settings set up so that people aren't recording meetings when they shouldn't be recording meetings, etc. Or they are recording them when they should be recording them, and where are those recordings stored, and those kinds of questions. And think about other privacy enhancing techniques. So we've mentioned some there. Encryption is a relatively simple and painless way of keeping data secure. The CIA of security, so that's about how are you maintaining the confidentiality, the integrity and the availability of information. So confidentiality, who has access to it, why do they have access, do they need access, how do you protect that? Integrity, how do you make sure the information is safe and it's accurate and it's up to date if it needs to be? And the availability, so how do you make sure that the information is available when it needs to be? So what protections do you have in place to stop hacking and those kinds of things? Do you have backups, for example? And also, are you testing your online services and your online protections to make sure that everything is as secure as it can be? Could I have the next slide, please, Amy? So more specifically in terms of online services, obviously this applies to any online service that you're using where that online service is utilising personal data. We're utilising personal data here because you've got my image, my voice, I'm talking, my name's on the screen. So Zoom is using my personal data. Have you checked your supplier's GDPR compliance? So are they compliant with the UK GDPR? And it's really important to not just presume that because they are a big supplier, because they're Microsoft, that they are compliant. It's not always the case. I was looking very recently for a client at a very well-known payment service. Who processed payment transactions. Sorry, it wasn't payment transactions, it was a marketing service, that uses, takes your email addresses and sends out your direct marketing. And if you read their GDPR compliance statement, or the UK GDPR compliance statement as it is now, it was brilliant. And they understood marketing and they understood PECA and they understood the rules, and that was perfect. Their terms and conditions, however, said, we are a data processor, and that was it. Nothing else, because obviously the next step, it's not just enough that your supplier is compliant, you also need to identify whether or not they are a controller or a processor when they take your data. If they're a controller, they're taking your data and using it for their own purposes. If they are a processor, generally they're taking your data and doing what you tell them to do with your data. Zoom is a data processor because they are operating the system on our behalf, essentially. I'm not going to let them take my information and use it to market to me, for example, unless perhaps I've given express permission, which I haven't, but they are usually a processor. So if you've decided that your supplier is a processor, you then need to look at the terms and conditions and make sure that, one, they are a legally enforceable contract between you and the supplier, and two, does that contract have the necessary and the mandatory UK GDPR requirements? So it's not just enough to say this is a data processing arrangement. There are specific clauses that should be in that agreement, and you need to check and make sure they are. And also check the practical issues. So I've mentioned before briefly about staff understanding the privacy settings. Do they know how to set those up? Do they know how to make sure that the information can't be accessed? If you are using something like Zoom and you're making a recording of a lesson, where are you storing it? Who has access to it once it's been stored? How secure is that? And so those kind of practical things you also need to look at. The next slide, please, Amy. I'm going to hand over to my colleague Claire now to talk to you about photos and videos.
Thanks very much, Vicky. Afternoon, everybody. So we thought we'd do a session on photographs and videos because this is an area we get asked about quite frequently. And it's an area that can be a little bit confusing as well because there is some flexibility and you do need to use your professional judgment a little bit around which lawful basis you're choosing to rely on to use photographs and videos. So, for example, when do you need to get consent? So that flexibility comes with the advantage, I suppose, that you get to decide what works best for your school in practice. But I'm going to talk you through kind of the key things to think about really when making that decision for your school. So start with the essentials is always the best thing to do with data protection, which I appreciate can be quite a confusing and a little bit unwieldy, some would say, of an area of law. It is always good to start with the basics and start with the essentials. So the first thing to think about is transparency. Now, transparency is all about explaining to people how you're going to use their personal data. So I would hope that your schools and your trusts have privacy notices in place for pupils, for parents, for staff. But today we're focusing, I suppose, on pupils because we're talking about photographs and videos for pupils. So I would expect that your pupil privacy notice has a section in it on how you use photographs and on how you use videos so that people understand how you're going to be using those types of images in media, for example. Now, the benefit of being really transparent, along with it being a legal requirement, is that in my experience, complaints about data protection can often happen when you use personal data in a way that people don't expect. So people generally turn around and say, well, I didn't expect you were going to use my personal data like this, therefore I'm going to complain about you to the ICO, that kind of thing. So being transparent with people, it helps to kind of manage their expectations and hopefully can minimize the risk of complaints. Now, coming back to that privacy notice I mentioned a moment ago, because parents and pupils are generally quite interested in how photographs are going to be used, I suggest really drawing attention to the section in the privacy notice about photographs and videos. So in the latest VWV privacy notice, we've actually put that section in a box to really draw attention to it. Now, I know that some schools and some trusts go even further than that, and they actually have a separate kind of short mini privacy notice specifically on images. And that's absolutely fine. There is flexibility around how you provide the privacy notice information. Providing it in a kind of mini privacy notice is what the ICO call the layered approach, because you have your big privacy notice, and then I suppose you've got kind of offshoots of bits and pieces of information that can make it more digestible, which is particularly important, I think, when we're processing information about children, that we're presenting the information to them in an accessible way so they know how their personal data is going to be used. So the next point to think about is, what is your lawful basis under the UK GDPR? So as I imagine most of you will know, whenever your school or trust uses personal data, you have to identify a lawful basis under the GDPR. Now, there are 6 in total, but for the purposes of talking about photographs and videos, we're going to focus on 3 in particular. So those lawful bases I should mention should also be mentioned in your privacy notices in relation to all kind of processing of personal data. So people should really understand which lawful basis you are relying on to process different types of personal data for different reasons. Now, when it comes to photographs and videos, you will sometimes be using them under what we call the public task lawful basis. Now, this is in some ways the most straightforward one because it's where you don't really have a lot of flexibility. It's quite prescriptive, I suppose. So if you are using a photograph of a pupil because they have a peanut allergy, for example, and staff members need to know that that particular pupil has a peanut allergy, and therefore there are certain, medical issues that go alongside that staff need to be aware of. If you're using a photograph for that reason, your lawful basis is going to be public task because it's part of your task as a school to take care of that pupil and to look after them. However, where things get a little bit more complicated is where we are using photographs and videos for marketing and promotional reasons. So these fall outside of the tasks, I suppose, that you would have as a school. It's a bit more of a discretionary use of personal data. Now, I think most of you listening to this are from the state sector. So you're from state schools, academy trusts, and you are what are referred to as public authorities for the purposes of data protection law. Essentially, if you're covered by the Freedom of Information Act, you're a public authority. Now, this means that you can't rely on legitimate interests for certain purposes. You can't rely on legitimate interests for carrying out your public tasks. But we can think about legitimate interests for activities and purposes that fall outside of your public tasks. So that's why we're going to talk about legitimate interests in relation to using photographs for publicity and marketing reasons. Consent is the other lawful basis that we'll talk about in a moment as well. And essentially, you need to choose between legitimate interests and consent when you're using photographs and videos of pupils. Now, legitimate interest is a slightly unusual lawful basis in that whenever you choose to rely on it, you have to carry out a balancing exercise. You essentially balance up your legitimate interest in using the personal data, and you balance that against the rights and freedoms of the individual. And if the rights and freedoms of the individual outweigh your legitimate interest, then you can't rely on legitimate interest as your lawful basis. So this means that in the context of photographs and videos, legitimate interest is appropriate for photographs and images with minimal privacy impact, used in ways that parents and pupils would reasonably expect photographs and videos to be used. So to give you a practical example, I suppose, a group photograph of a group of children on the website without their names, nothing particularly unusual, used in a way that parents reasonably expect. You could use legitimate interests for that type of use. However, if you're using a photograph or video in a more unusual way, a more privacy intrusive way, then probably not going to be able to rely on legitimate interests for that. And that's where consent comes in. Now, I mentioned at the beginning that there is some flexibility here, and I am aware of a lot of schools who just get consent for all uses of photographs and images that are going to be used for kind of non-educational, non-welfare purposes, and that's absolutely fine. But I also speak to some schools and some academy trusts who say that actually the burden of getting consent, because consent is quite a high threshold, which we'll talk about in a moment, they prefer to rely on legitimate interests where they can. And that's a really important thing here, that you can't rely on legitimate interests for all uses. You probably can for some of those kind of minimal privacy intrusive impacts. So it's really up to your school and your academy trust to decide when you want to rely on legitimate interests, satisfying yourself that legitimate interest does apply to those photographs and images, but then getting consent for the rest. Now, when you rely on legitimate interests, you need to document that you're happy that you can rely on it. The ICO refer to this as being a legitimate interests assessment. You essentially identify your legitimate interest, show the processing is necessary to achieve that legitimate interest, and then, as I said, carry out that balancing exercise The ICO, most importantly, require you to document that exercise. So do remember to do that. And that would be very helpful if you do get any complaints about how you've been using photographs and videos as well. But we need to talk about consent, don't we? Because I know a lot of you listening to this will be thinking, well, we get consent for everything. And like I said, that's fine. It's fine to get consent for everything, as long as the consent that you are getting is of a UK GDPR standard. And this is where, in my experience, quite a few schools come unstuck because they put something maybe quite vague in some joining information, maybe just saying, you know, we will use photographs of your child for publicity reasons. And then that's it. That's the only information given. But for reasons I'll explain in a moment, I don't think that meets the threshold for being proper consent under the GDPR. So consent under the GDPR has to, first of all, be freely given. People must be given a genuine choice about whether they're going to consent, whether you're going to use their personal data or not. So if they were to say no, and then you were going to use it anyway, that means consent isn't the appropriate lawful basis here. They must have a genuine choice. You are giving them the power to decide if you can use their personal data or not, whether you can use their photograph for the reason you've asked that consent for. It can't also be made a condition of a contract. So you can't put it in kind of a contract you had with parents if you had something like that as well. Consent has to be specific and informed. People have to understand what they're consenting to. So as I mentioned a moment ago, a vague consent request in respect of all photographs and videos used for marketing isn't really explaining to people what they're consenting to. So make sure that when you do seek consent, that the pupil or the parent, whoever's consenting, that they actually understand, you know, are you going to be using photographs of them on Twitter? Are you going to be using photographs of them on Facebook? And if so, you know, what type of photographs? Do you use names with photographs? That kind of thing. So these are the types of things you need to be explaining to people when you seek their consent to use a particular image. Make sure that the consent request as well is requiring an unambiguous indication. So it has to be a positive opt-in. You can't say to people, we're going to use your image, and if you don't tell us we can't, then we will assume you can consent. That's not consent. You can give opt-outs, but that won't be consent. You'd be relying on legitimate interest as your lawful basis instead for that. So be very careful about making sure that any consent requests you are putting out there in consent forms, or maybe you're speaking to people face to face to ask them for consent, just make sure that you are meeting that threshold. I have to point out as well at this stage that people can withdraw their consent at any time. So when you are relying on consent as your lawful basis, you are giving people all of the power about how you use their personal data. Now let's have a think about children here and children and consent. So generally speaking, from about the age of 12, children are able to exercise their own rights. If a child has special educational needs that maybe limit their understanding, the age of 12 probably isn't appropriate for that particular child. But as a general rule, it generally is 12. I know that a lot of schools say, well, our parents also expect to be asked for consent as well. It's fine to ask both the pupil and the parent for consent. So I'm aware of some schools who say that between the ages of 12 and 16, they will ask both the pupil and the parent for consent. And then sixth form, generally people go with just asking the pupil for consent. So, like I said, you need to choose between consent and legitimate interests for some of those less privacy intrusive images. But where an image is more privacy intrusive, then consent will be appropriate. For something that's very privacy intrusive and very unexpected, so give you an example, I know some schools use photographs on billboards or on the side of buses, something really privacy intrusive. I really do recommend speaking to the pupil and the parents specifically about that particular photograph, rather than relying on a tick box, kind of something they put on a form a few months ago. Because I think there's an argument that if it is going to be quite unusual and privacy intrusive like that, for it to be valid consent, they really do need to understand specifically what image you're going to be using of them. It also, from a practical point of view, minimises the risk of complaints, because you don't want to spend loads of money on a big advert for the parent or pupil then to turn around and tell you to take it down because they don't like the photograph. So it does help to have that dialogue with the child and with the parents when you're going to be kind of splashing out and spending quite a lot of money on your marketing, that kind of thing. So as I said, you need to work out what works best for your school. So, there is no requirement to rely on legitimate interest for certain things. There is, though, definitely a requirement to get consent for very previously intrusive uses. But there's that grey area in between where you need to kind of think, well, what works best for us in practice? And what do our parents expect from us? That's obviously a big factor as well. Can I have the next slide, please, Amy? So at the start of 2020, the Information Commissioner's Office, who are the data protection regulator, actually gave a couple of reprimands to schools, a couple of schools, in relation to the use of photographs and videos. So what had happened in these two particular cases was that the school had used a photograph, even though the parents had said not to. And in these two particular cases, there were actually safeguarding issues here. And that's why they got reprimanded by the ICO. So do remember, as I don't think I need to tell you this, but obviously safeguarding is really, really important. Data protection does not in any way stand in the way of you fulfilling your safeguarding obligations. So please make sure you've got robust procedures in place to prevent images being used of children where that could raise a safeguarding issue. I imagine that quite a few of you have probably got a list of pupils where you know that child can't be photographed. So, for example, if there's an estranged parent who isn't supposed to know where the child is at school, makes sense that child's photograph then can't go in that school's perspective. And that's really the high risk area here. So please do make sure you're training staff and that you've got robust procedures in place around that type of risk. The other thing I wanted to mention was staff and using devices to take photographs, because I know it's very convenient sometimes for staff to use their own devices, but that raises information security issues. And information security and data breaches, they are the high risk area of data protection law. So if a staff member is using a school-owned device, that means that your IT team can make sure that that information, that image on that device is kept secure. It means that it's within your school's control. Whereas if a staff member is using a personal device for photographs and videos, not only does that raise a risk for the staff member in themselves that they've got images of pupils on a personal device, it also raises risks for your school as well. So do make sure that you've got procedures in place and also the resources in place so that staff members do have access to school-owned cameras, school-owned phones, if they're going to be taking photographs on a school trip, for example. Make sure you've got those measures in place, and also make sure that you're documenting what measures you've got in place and what training staff have been given. Because if something does go wrong, then we've got the evidence for the ICO that you did have all the right things in place. It was just, human error that something happened. I'll talk about accountability in a section later this afternoon, but demonstrating compliance is really quite a key aspect of data protection compliance at the moment. Next slide, please, Amy. Okay, so I'll come back to documentation again. So I mentioned the privacy notices at the start of this section about being transparent with people about how you're using their personal data. When it comes to photographs and videos, I do recommend that schools actually have written guidance in place for staff members on what your school's kind of policy is around photographs and videos. Are there just particular staff members that have permission to publish photographs on social media on the school website? And if so, who are they? Do staff members know who to speak to if they want to get a photograph published? What documentation have you got around the fact that you might use an external photographer who is probably going to be your school's processor? What contract have you got in place with that photographer? As Vicki mentioned, when you're using a service provider who's processing personal data on your behalf, there has to be that contract in place, and you have to be doing due diligence on their data protection compliance as well. Again, as Vicki mentioned, and we know a lot of schools are using apps at the moment, and those are particularly kind of focused on photographs, maybe sharing photographs with parents, maybe sharing photographs with the world at large if you're doing a publicity event. If you are using an online service or an app, do make sure that you've got those robust measures in place, those security measures in place. What security checks have you done on the service provider? Do you have that contract in place that we mentioned already? So these are kind of all the kind of the data protection things that you need to be thinking about whenever you're using personal data. They all apply to using photographs and videos. It's just that using photographs and videos is something we get asked about quite a lot, because it is, I suppose, quite a high profile use of personal data. And when it goes wrong, it can be quite emotive as well. The last thing I just wanted to mention on this is staff members should really very much use their common sense when taking photographs and videos. So if they know that a particular pupil is maybe a little bit self-conscious about the fact that they're wearing a brace, for example, or there's some other reason why they might not want their photograph taken, maybe just, use your common sense. Don't use that particular image. You should also be using kind of discretion around when it's appropriate to photograph children wearing sports kit, particularly things like swimming wear, that kind of thing. And I think consent is particularly important when you are going to be using a photograph of a child in maybe a more revealing outfit or a costume for a school play, something a bit more unusual, does point in the way of in favour of getting consent rather than legitimate interest. Next slide, please, and I'll pass back to Vicki now to talk about subject access requests.
Thanks, Claire. What I should have done for Claire's last section, which I've failed to do this time, is I've got a fantastic photo of my daughter, who is 11, on a ride at Disneyland, and her face, it was a dinosaur ride. She doesn't like it. She looks horrified. I love the photo because you know exactly what she's thinking on her face. She hates it. But she has allowed me to use it in these presentations to illustrate that exact point, that you might think it's a lovely photo and that it's brilliant, but actually the child hates it. So you really need to speak to them about, are they happy? I assure you, she is normally happy for me to produce it. And next time I'll stick it in our slides because it is lovely. Anyway, subject access requests, and particularly in relation to the exam period. So you're all gearing up to release exams, slightly different again this year with what you've had to do, and slightly different process for reviews and appeals, and you've got all these new deadlines. Under this new regime, there is actually a requirement on the school to provide the basket of evidence to students to show them how their grades were calculated. So what we are expecting is that this will cut out some of the subject access requests that we saw last year when you weren't required to give that evidence. So now you're required to provide it. In theory, a student should have everything they need in order to make a decision about whether they ask you to review or appeal their grade. So you don't have to treat a request for that information as a subject access request. You should just be handing that over, so that's fine. Anything that you are any request that's made for information outside of that basket of evidence that you're required to provide, however, would be a subject access request, and so it has to be dealt with in the normal way. 1 month deadline, checking for any exemptions, etc. So it would be a normal subject access request. And where we think these requests are likely, two scenarios: where you've got a scenario where a parent is or a pupil is just generally unhappy with you, and we all know that you get those parents occasionally. They don't like the school, they don't like the teachers, they don't like the exam results, and so they decide to make a subject access request just to be a pain, basically. So they'll ask you for everything. So that's a possibility. We also think that because this year, if you do request that formal review and appeal, there is a risk that your grade will go down. It's possible that parents may decide, rather than actually, or pupils it should be, but we all know it's usually the parents, so they might not want to actually make that formal review or appeal request in relation to the grade, but they might want to make a parental complaint instead, because then the grade is not at risk. And if they are making a complaint, their complaint may be slightly wider than the specific information that's been requested, that they've been provided with, so there may be subject access requests for those. Can I have the next slide, please, Amy? So our advice, triage your requests as much as possible. So if you do get a subject access request that relates to information that's going to be relevant to a review or an appeal, you've got those very, very tight deadlines, particularly for your A-level students with the UCAS, etc. So deal with those quickly, deal with those as quickly as you can. And ones that are general requests for everything that aren't really related to it, well, you can put those on the back burner. You've got a whole month to deal with them. If they come in on the 10th or the 12th of August, you've got until the 10th or 12th of September potentially to deal with those, which is slightly after those immediate deadlines. So you can triage them. But if you are doing that, be open with parents. Claire's already mentioned the transparency thing can really help. And if you know that you're not going to deal with something in the first 2 weeks, be honest about it and say, it's not possible for us to deal with this within the deadline that you have given. We have a statutory deadline of a month, and we will endeavour to get it to you within that month, or however you want to phrase it. But just be open with people initially. One question I have been asked is, well, we're required to give the student the basket of evidence. What else can they ask for? And the answer is, I don't know. Having looked at what you're required to provide, I can't off the top of my head think that there would be anything else that might be relevant. But there is always one parent that finds that extra bit of information that might be relevant. So you might want to be helpful and provide that early. So just be prepared for that, as I say, and make sure. And one of the key things actually is making sure that the staff members, and we said this last year, who are giving out the grades and who are having that one-to-one contact with the pupils, understand that if the pupil on the day says, I want information about something, this subject, my performance, whatever it is, if that falls outside of that basket of evidence question, it's a subject access request, it's a valid one, and it has to be dealt with. But it won't be dealt with if the member of staff doesn't recognise what it is and make sure that it goes through the proper channels. So do make sure that everyone, again this year, who's dealing with that and dealing with pupils and parents on that one-to-one basis, knows that you can make a formal request for information face-to-face. It doesn't have to be in writing. You have the next slide, please, Amy, and I will pass back to Claire to talk about documentation and accountability.
Thanks, Vicky. Brilliant. So if you cast your minds back 3 years ago, just over 3 years ago, actually, time flies when you're having fun, to when the GDPR came in May 2018, one of the sea changes really, and one of the main differences between the Data Protection Act 1998 and the GDPR is this requirement around being able to demonstrate your compliance. So Data Protection Act 1998, you'd have to comply with it. GDPR, or UK GDPR as we're now calling it, you have to go further than even just complying with it. You have to actually demonstrate how you're complying with it. And I'm afraid that does mean documentation and, dare I say it, paperwork. But help is at hand. We're here to help. So make sure that your documentation reflects your practices. I get sent quite a lot of data protection policies drafted by schools to review and to amend. And one of the main themes I notice is that schools sometimes are great at writing down what data protection law says, full stop. They don't go that extra mile in saying, well, this is what we do to comply. This is what we do in practice. And your policies, your documentation, they should be tailored to you. They should be specific to you and the school context as well. So there's no point taking kind of a data protection policy that could work for anyone. It should be school specific, because there are unique challenges that schools and trusts face as a result of the fact that you're handling huge amounts of sensitive data, children's data, that kind of thing. So make sure they do reflect the practices that you have in place. Part of accountability as well is making sure that the measures you have in place are effective. And this means assessing those measures on a regular basis, essentially. Now, there should be two types of measures you have in place to comply with the GDPR and to keep information secure. Technical measures, and those are the things that your IT team will be responsible for. So you've got your network security, your encryption, your firewalls, your antivirus, protecting you from ransomware, those kinds of things, your technical measures. Then you've also got your organizational measures. Those are your staff training, your procedures, your policies. And both types of measures need to be appropriate and they need to be effective. And one way of making sure they are effective is to test them, is to stress test them. Ideally, you would do that before something goes wrong. But I'm also a big believer that when things do go wrong, even if they've only gone slightly wrong, a little bit of a near miss, how could you use that as an opportunity to think, how can we improve the measures we've got in place? Do a lessons learned exercise. And coming back to this point around demonstrating your compliance, document that near miss you had when someone almost sent an email to the wrong person but didn't. What could you do to prevent that from happening? Learn from all those things. And this is where your staff, your colleagues are really valuable, because sometimes the best ideas come not necessarily from the person who leads on data protection, but from the people on the ground who are dealing with personal data on a daily basis. They sometimes have some of the best ideas. So do involve your colleagues in this kind of collaborative effort around stress testing the measures you've got in place and making sure that they work well in practice. Speaking of working in practice, one of the things that you should make sure is that these kind of policies and procedures you have in place, make sure they do work in practice. Do they actually work for your school? They might look like they're brilliant on paper, but if they're not actually working in practice, people just won't do them. So do make sure that you are thinking kind of clearly about how this is going to play out in practice if you want to implement a new procedure, for example. Can I have the next slide, please? Thank you. So the Information Commissioner's Office, who are the data protection regulator, they published in draft form in 2020 their accountability framework. It's quite a long document, it's about 100 pages long, which goes to show just how seriously the Information Commissioner's Office are taking this accountability requirement. Now, the accountability framework kind of makes it very clear that accountability is not a tick box exercise. It's not a matter of drafting a brilliant policy and then shoving it in a drawer until it next needs to be reviewed. These are working documents. They should be kind of, as I said, practical. They should be, all staff members should be familiar with them. All staff members should have training on them. They should be on your intranet. Everyone should know where to find them if they need them. It's not a tick box exercise. It is about building this culture of data protection. And they're also not kind of one-off exercises. It is an ongoing obligation. So you can't kind of think about data protection for one day a year and then forget about it. You do need to be thinking about this on a daily basis and building that compliance into your day-to-day activities. There's a term called data protection by design and default, which is about making data protection, kind of baking it into all your practices. So have a think about how you're doing that as a school and a trust. And again, I'm afraid, make sure you're documenting how you're doing that. So if something were to go wrong, you could show the ICO actually what you've done in practice to be compliant with the law, because the ICO does have the power to ask you for documents to show your compliance. Those of you that have had to report a data breach to the ICO will probably remember that on the data breach form that you have to fill in to notify a data breach, the ICO do ask questions like, well, what staff training was in place for this particular staff member? And if you don't have a record of that, how are you going to tell the ICO? So this is the importance around keeping this kind of paper trail of data protection compliance. Next slide, please. So I've kind of been talking in quite broad terms so far, but let's talk about the specifics. So the question you're probably all asking right now is, well, what documents do we need specifically? Now, there are certain documents that are explicitly referenced in data protection law, and I'll go through those now. So we've already mentioned privacy notices, which is the importance of being transparent with everybody whose personal data you use. Now, I recommend that schools have pupil privacy notices, which are separate from the ones given to parents, because how you're using pupil personal data is going to be different to how you're using parent personal data. And I mentioned that children can exercise their own data protection rights from around the age of 12. So from that age, you should be giving the child themselves a privacy notice, which is age appropriate. So not full of technical jargon, but actually explaining in age appropriate language how their personal data is being used. You should also have a privacy notice for staff, and that can also cover your governors and trustees and volunteers if you would like it to, but make sure that anything specific for those groups is explained. And I'm also a big fan of having a staff privacy notice that can also be used for prospective employees, just to kind of limit the amount of paperwork you do need to have. Privacy notice as well, you might also need one for any alumni if you're a school or a trust that does a lot of alumni work or fundraising work. I know a lot of schools as well will collect personal data through their website. So think about having a privacy notice for your website as well. You are required under the UK GDPR Article 30 to have a record of processing activities, This is essentially a record that outlines what personal data your school or your trust uses and various other points in relation to that use of personal data. For example, the recipients, any processors, any service providers that are accessing that personal data on your behalf, those type of things, what security measures you have in place in relation to the personal data as well. The Data Protection Act 2018 requires you to have an appropriate policy document for special category data. In addition, data protection policies for staff are referenced in the UK GDPR. They're referenced relatively generically because obviously the UK GDPR applies to all sectors, it's not education specific. But in a moment, I'll outline what I think is appropriate for data protection policies for schools and the education sector as a whole. You are required to keep a data breach register under Article 33. So this is essentially a register of any data breaches you have. So not just those that have to be notified to the Information Commissioner, but any data breach you have. Data protection impact assessments are something that the ICO are increasingly focusing on. A data protection impact assessment, or DPIA for short, is essentially an exercise where you think about how you can identify and then mitigate the risks from certain high risk uses of personal data. So a DPIA is mandatory where you're going to use personal data in a way that's likely to result in high risks for the individual. However, there's no reason why you can't do a light touch DPIA just when you're starting to use personal data in a new way and you're trying to get your heads around how you might be kind of compliant with data protection law in relation to this new use of data. In relation to kind of it being a mandatory requirement, you should be doing a DPIA if you use biometric information, for example, or if you have a lot of CCTV being used at your school. I think that's an area where a DPIA should be done as well. Vicki I already mentioned contracts with processors. So it is a mandatory requirement to have a contract with your processors, so the service providers using personal data on your behalf, and that contract has to contain certain mandatory provisions as well. So I mentioned staff policies. Now, as I said, the GDPR is not prescriptive on specific policies for staff. It says that you should have appropriate policies in place. Now, I think, having advised schools for a number of years, that it's really useful to have practical written guidance for staff on the do's and don'ts. So we at VWV refer to that as being the data protection policy for staff practical guidance. In addition to that, information security is the high risk area of data protection compliance. So have an information security policy. That's the kind of thing that will go through password requirements and how staff members work securely from home. It's also, I think, best practice, although arguably not a legal requirement, to have guidance on photographs for staff members. You know, think about that point I was making a moment ago about staff members using devices. That should be written down somewhere, whether it be used in an information security policy or a different policy. Photos guidance as well could cover off things like when to get consent and how to get that consent as well. And accountability is such a broad concept because it does affect all data protection compliance, that it can be useful to have an overarching data protection policy. Now, this isn't for staff members per se. This will be more of an external facing document that kind of says, this is how we as a school or as an academy trust, this is how we comply with data protection. And that could be published on your website to give reassurance to parents, for example, that you know your data protection obligations. I also recommend having a data breach procedure. This would be an internal document that you can turn to when you have a data breach, because it's obviously quite a stressful thing. If you've got a procedure that you can follow, it just really helps you kind of think clearly in that kind of really stressful situation post data breach. You should also have a retention schedule outlining for how long you keep personal data, and records of staff training as well. Vicki will talk about staff training in a moment, but do keep records of staff training so that you can evidence that that training has taken place. And I've already mentioned legitimate interest assessments. So on those rare occasions when you rely on legitimate interest, you should document that balancing exercise that says that you can rely on legitimate interest. There are a host of other things as well, I'm afraid, which are probably too numerous to cover in this short webinar. But just to give you one example of another type of thing that you should be thinking about, it's subject access requests. as Vicki was talking about a moment ago, you should have records relating to any subject access requests that you've responded to. So which exemptions you relied on to withhold information should be documented. As I said, there are other procedures as well that will be unique to your school that I can't go into now, but maybe have a think about what types of procedures you need to have written down so that if something does go wrong, you can demonstrate your compliance. And I'll pass over to Vicki now for a section on staff training.
Thanks, Claire. So we've been talking about, Claire was talking there about your policies, making sure that they reflect what you actually do or what you want to achieve, rather than just having a standard suite of policies. And staff training is exactly the same. It's all very well giving some generic training to your teaching staff about the data protection principles, and I'm sure that would be really interesting to them. But it doesn't help them understand how that translates to when they're stood in front of a classroom and they share their screen and they accidentally share some assessment data on the screen that they shouldn't have. How does that apply? Is that a data breach? What are the issues with that? Why was the assessment data on the computer in the first place? And all of those things. So we really recommend that when you are training staff, and we're not just talking about teaching staff here, we're talking about any of your staff who deal with or have access to personal data. So your IT team, your marketing team, your teaching staff, your SLT, your governors, all of them, they should have training that's practical. So it talks about what are their specific obligations in their role. What are you expecting of them? What are the consequences if they don't get things right? It should be education sector specific. As Claire mentioned at the beginning, schools deal with a lot of very specific types of data, pupil data, attainment data, assessment data, that a general private sector organisation, say someone like VWB, just won't use on a daily basis. So it needs to be specific to your sector. And we also recommend that it encourages questions and suggestions. So it's not just a case of putting Claire and I in front of your staff and we give them, a brilliant hours sort of training on the do's and don'ts of data protection, but they need to be able to ask questions, make suggestions, and so that you know that they actually do understand what you've told them, so they take away from the training what they need to take away from it. We've mentioned on the slide about role specific training too, and that's really helpful because what your DPO needs to know is very different to what a teaching assistant needs to know. What your marketing team need to understand about the privacy and electronic communication regulations and getting consent for direct marketing is very different to what your governors need to understand. So make sure that as far as you can, it's specific to the audience you have in front of you. And I did mention governors before, and I say that don't forget governors. And I say this as a governor of a school, and I've been a governor in the maintained sector as well as the independent sector. They are potentially sometimes your weakest link, and you need to make sure that your governors understand that when they are receiving information, personal information about staff because they're doing some sort of pay review, or they're looking at staff complaints because it's gone up to governor review level or whatever it is, that they understand the basis on which they're receiving the information, that it doesn't belong to them just because it's on their personal email address or their personal account. It still belongs to the school, and the school and the trust are still responsible for it, and they understand the expectations about how they keep that information safe. I always tell this story when I'm doing this type of training, and I never reveal the source because I think they would be horrified. But when I was a governor a long time ago now, so not at the school I'm currently at, I was just chatting to one of the other governors who was a highly respected professional in an industry where I would have expected them to have understood in great detail about data protection and the need to keep information secure. We just happened to be chatting about the fact that this individual was a safeguarding governor, so they had access to lots of information, pupil level information about incidents, etc. And they happened to mention that it was all just in their downstairs office, and that was okay, wasn't it? No, it's not, because anyone has access to that downstairs office. The members of the governor's family, anyone who comes round for tea, anyone who comes around for a dinner party, wasn't locked away, wasn't stored out of sight or anything like that. So do make sure that you remind your governors, as well as everyone else that you deal with in your organisation, that it's their responsibility as well. And it's actually their responsibility to make sure that the culture in your organisation is a culture of data protection, and it's a culture of accountability, and it's a culture of transparency. And so they can't do that if they don't themselves understand what it is they're supposed to be promoting and helping you with. So don't forget your governance, really important. I will hand back now to Claire to talk about our final section. If we can have the next slide, please, Amy. Thank you.
Thanks, Vicki. So yeah, just a very quick section because I want to leave some time to answer the questions that you've very brilliantly been asking us. So international transfers following Brexit. So I'll start with a bit of a recap on Brexit, because obviously it's been a year since Vicki and I did a session for you guys. And since then, the end of the transition period for Brexit happened at the very end of December 2020. This essentially means that we now have the UK GDPR. So you may have noticed when we've been talking that Vicki and I have been referring to the UK GDPR. That's to distinguish it from the EU GDPR. So what happened basically at the end of 2020 is that the GDPR got copy and pasted essentially into UK law. Some tweaks were made to make it kind of work in a UK only context. But we do now have the UK GDPR, which is distinct but very, very similar to the EU GDPR that obviously continues to apply to Europe. I wanted to talk about international transfers because that's something that is in the press at the moment a little bit, and it's also an area of law that's very quickly changing. So this is a bit of a whistle-stop tour on international transfers, but I thought it'd be useful just to go through the basics on international transfers for you. So essentially, when personal data leaves the UK, you have to make sure that it remains protected. So the term essentially equivalent protection is used in relation to that protection. So if you transfer personal data outside of the UK, you need to make sure that it's being kept secure and that data protection rights still apply to it in the country that it's going to. Now, helpfully, a lot of countries have been deemed by the UK government, well, really by the EU, and then we essentially copied it, how deemed to have adequate data protection law. So when you transfer personal data to those countries that have adequate data protection law, you don't need to worry too much, because that exercise around do they have adequate data protection laws, that's already been done by the EU and the UK. To give you a few examples, the UK government has confirmed that all countries in the European Economic Area, that's the EU plus Norway, Iceland and Liechtenstein, they are deemed to have good data protection law because they've got the GDPR. So it's fine for personal data to go from the UK to the EU and the Norway, Iceland and Liechtenstein. In the last couple of weeks, it was brilliant news that the EU have deemed that the UK has adequate data protection law for the purposes of the EU GDPR. So it wasn't a total shock because we did essentially kind of keep the GDPR as UK law, but that means that now personal data can freely flow between the UK and the European Economic Area. So in practical terms, that means that, you know, COVID restrictions, I know, mean that trips haven't been happening abroad this year, but let's say next year you fancy going on a school trip to France and you're sharing personal data with a hotel or an activity provider in France. That personal data about the pupils, that can freely flow between France and the UK. Now, there are other countries as well that have adequate data protection law, but unfortunately, they're kind of few and far between. I mean, the notable examples are New Zealand, Switzerland, Argentina. So if you did want to send personal data to New Zealand, for example, that's great. Information can freely flow between the two countries. Can I have the next slide, please? However, there might be times when your school wants or needs to transfer personal data to a country that doesn't have adequate data protection law. Now, a relatively common example is the USA, and there's been quite a lot in data protection kind of sphere about the USA and its data protection laws for a reason I'll explain in a moment, around a case called Schrems 2. But the reason I mention the USA in particular is that obviously a lot of tech companies are based in the USA. So you might be transferring school personal data to a company in the USA by signing up to a new online platform for educational reasons, for example. So again, one of the reasons why it's really important to do those checks on your service providers to find out how they are complying with data protection law. So if a country doesn't have adequate data protection law, you have to put in place a safeguard to keep that personal data secure. Now, one of the most common examples of a safeguard that's in the GDPR, or the UK GDPR as well, are they called the standard contractual clauses, or SCCs for short. And essentially what you do is you put these mandatory clauses in a contract with the organization you're sending the personal data to abroad, and that those contractual clauses are in theory supposed to protect that data. However, there's a bit of a hitch, I'm afraid. In 2020, there was a case called Schrems 2, where a privacy campaigner called Max Schrems essentially pointed out that in relation to the USA, they have very broad sweeping powers for public authorities to access personal data. And his argument was that those powers undermined the SECs. So, and he essentially won that case, for want of a better word. And in light of that case, you now have to you have to do an assessment essentially to check what measures, additional measures you might need to put in place in addition to the standard contractual clauses. Now, the Information Commissioner's Office have been very pragmatic on this at the moment, because they appreciate that doing an assessment of another country's data protection law is not an easy undertaking. So at the moment, we are waiting for the ICO to publish guidance on this. That will hopefully be coming soon, because the ICO have confirmed that they will be publishing UK specific standard contractual clauses over the summer. So hopefully within the next few weeks. And fingers crossed, we don't know for sure, but hopefully they will be publishing that guidance on the Schrems 2 decision at a similar time to publishing those new SECs. It would make sense for them to do so anyway. So at the moment, we're in a bit of a limbo situation. If you did want to look at any guidance on this, the European Data Protection Board have published guidance, but because we've now left the EU, that's not directly applicable. So it'd be interesting to see what the ICO say works in a specific UK context on that point. But that is an area of law that's rapidly changing at the moment. So do drop us a line if you'd like to stay up to date with that area of law. And for those of you that aren't already signed up, we do have the data protection module of our compliance toolkit, which is a monthly updating service for a small fixed fee. And we do put stuff in there about international transfers as and when appropriate. But with that said, I'm conscious of time. So let's have a look at some of your brilliant questions. So Vicki, you want to come off mute as well? That'd be brilliant. Have a look. So question about privacy notices for job applicants. Yeah, so absolutely. I think staff privacy notice can also be used for prospective staff as well, and for job applicants. Obviously, you need to make sure that your staff privacy notice does cover the relevant points that would be appropriate for those individuals. Yeah, so I think I slightly disagree with your DPO. I don't think you necessarily need to have a separate notice, but the key is that the information is provided to the individuals. How you do that is your decision. The key is that you're providing it, it's clear, it's accessible, and that you're actually providing it to them actively. So rather than relying on them to go on your website and find your staff privacy notice, or wherever you publish it, it doesn't have to go on your website. You make sure they know where to find it. And I think the second question is similar. So governors, trustees, again, it's a matter of providing the information in a clear way. It doesn't actually have to be a separate privacy notice. I mean, there's no reason why you can't have one if you want to, but at the end of the day, I'm conscious that you have to have quite a lot of data protection documentation already, as I was describing. So I do try and minimize the amount of data protection documentation I recommend you have, just because it's so unwieldy otherwise. So yeah, key is you're providing the privacy information. How you do that is kind of your decision. There's flexibility there. Vicki, are there any that you wanted to pick up? There's one on freedom of information.
Yeah, so I've received a freedom of information request from the Guardian this morning. Anything I need to be aware of? Well, that depends on what they've asked for and whether you're happy to give it, essentially. It's probably not a question for today, but if you want to drop Claire or I an email, we can assist if that would be helpful. We've also got a question about should a DPO supply an annual report to the senior leadership team and governing board? There seems to be a grey area. There's no legal requirement for that, in that the UK GDPR does not say your DPO must do this. But the question I would ask is, how do you as an organisation know that you are compliant with the UK GDPR and Data Protection Act if you're not getting an annual report? It seems to me to be a simple or one simple way of getting that information. So it's the responsibility of the school or the trust to make sure that you are compliant and to make sure that your DPO is doing their job. And how do you do that if you don't have a report? So I would have said it would be a good thing to have, I think, would be the answer. Maybe not strictly required, but definitely helpful.
There's a question around photos for me around consent and being the age of 18. So no, it's actually the age of children can exercise their own data protection rights when they have the understanding to do so. It's generally deemed to be around the age of 12. The age of 13 is sometimes mentioned as the age at which children can consent. It's a little bit confusing, I'm afraid. The age of 13, consent at that age is specifically in relation to online services. So that's actually built into the law, that when Facebook, for example, or Twitter, when they are seeking consent, it has to be at the age of 13. But what we're talking about here is kind of outside of that online service sphere, essentially. So we're talking about consent for all sorts of things. So it might be consent for photographs, it might be giving them a privacy notice, it might be when can they make a sort of access request, it might be when can they authorize a parent to make a sort of access request. That's generally considered to be from the age of 12, but as I said, that's not written into the law for England and Wales. I think Scotland's slightly different. So you do have to use your judgment a little bit, and I know it does vary from school to school a little bit. But yeah, no, it's generally it's the age of 12. But as I said, I know some schools say, well, our parents expect us to ask them for consent. That's fine. You can ask both the pupil and the parent for consent, up to 18 if you choose to. I should just mention there is one area of law. It's actually not data protection law. It's actually the Protection of Freedoms Act in relation to biometrics. If you use kind of a fingerprint recognition for school lunches or that kind of thing, I know some schools do cashless catering. The Protection of Freedoms Act says that you have to get written consent from at least one parent to use a pupil's biometric data, and that's up until the age of 18. So that's the one area where it is parental consent to the age of 18. There's one more question on consent actually around, do we have to go out to parents to gain consent on a yearly basis, or can it cover 5 years at school? This is an area as well for your judgment, I'm afraid. This is why photographs and videos is such a difficult area, because there's so much flexibility. You need to be refreshing consent when appropriate. I'm afraid the word appropriate is used a lot in ICO guidance and a lot in data protection law. I know the rule of 2 years is often used sometimes by schools, but it's not a kind of a proper rule. It's kind of a use your discretion. What I would say is think about this from the point of view of the person consenting. If you're a parent and you ticked a box when your child started at school in year 7 and now they're in year 11, now what would your feelings about that be? I'd be a bit kind of wary, I suppose, of relying on consent that's that old. So I know annual consent is something a lot of schools do, and I think that's probably the safest option, but I can't hand on heart tell you that annual consent is a legal requirement. It's what's appropriate, thinking about what people's reasonable expectations are.
We've got a question about governors. Should governors be given school email addresses rather than using their own personal email addresses? Yes, is the answer to that question. It's not a legal requirement. It is perfectly acceptable for governors to use their personal email addresses for school business. And you may have governors who will refuse to have school email addresses. I've had that experience. It may be too expensive and just not practical to give them school email addresses. But the advantage of that is if they have a school email address, you control the access permissions to that, and you control as a school where it's stored, and how secure that storage is. If you have a governor who's using a Hotmail address or a Gmail address, whatever it might be, you have no control over that, and where that's stored and who has access to that, and you also have no control over the access permissions to that email address. So ideally, yes, we do understand that there are and there can be issues with that, but actually, if you can give governors school email addresses, we think that's absolutely the best way to approach that.
We have a question about, do we have a must and a should list to meet data protection GDPR compliance? We don't have one in relation to all of data protection, I'm afraid, because that would just be too unwieldy. But if that question is in relation to documentation, I think I might have done one for another school before, so I might be able to dig one out. So if you'd like to contact me separately, we can maybe have a chat over the phone about it and I can put something together for you. Does BWV offer more in-depth training? Yes, absolutely. We can offer whatever training that you would like. So back in the olden days, Vicki and I used to regularly kind of go and visit schools to give training. We can give training to your senior leadership team. We can give training to your governors. We can give training to your marketing team, because as Vicki mentioned, certain roles do require specific training. Vicki, is there anything you want to add on that training point? Sorry, that was kind of your section.
No, that's fine. Yeah, absolutely right. We can we have VWV Plus as well, and we have so we have lots of sort of generic-ish training available, but we're also happy to come in and give specific if that's helpful.
You spoke about a data breach register. That would have been me, and this should also include data breaches that aren't deemed reportable. Could you give an example of this? Yes, yeah, absolutely. So all data breaches need to be put in your data breach register, but only data breaches that are, the starting point is that data breaches are reportable, but you don't have to report them if they're not going to cause a risk to individuals, essentially. So there's a bit of a kind of a difference, there's a gap, essentially. So to give you an example, if you accidentally sent an email to the wrong person, that would be a data breach because it would be a breach of confidentiality. However, if the email contained very, very little personal data, really kind of routine personal data, nothing particularly sensitive, and the individual that mistakenly received it was really reasonable and realized it wasn't for them straight away and deleted it and reassured you they deleted it and they weren't going to do anything with the information they accidentally received, that's probably not going to cause a risk to individuals. So that's probably not going to be reportable, but it's still a data breach and you should still do a lessons learned exercise on how that email ended up being sent to the wrong person. That's the kind of low level data breach that should go on your data breach register.
And I think it's really important with the data breach register, because I've had this conversation with clients in other areas, that if you have a very full data breach register, it doesn't mean that you are not compliant with UK GDPR and you are not a very good organisation. It actually means that you are very compliant with UK GDPR, and it clearly demonstrates that you understand what a data breach is. You are recording them properly and appropriately, and you are taking steps to address them where it's appropriate to address them. And we quite often do due diligence exercises on companies when companies are buying and selling each other. And one of the questions is always, how many data breaches do you have? And the number of times I hear none, and I think, you've had no data breaches in the last 4 years. That is nonsense. And I do not believe you. You are not recognising your data breaches and you're not recording them. And that is far more risky and damaging than actually knowing what a data breach is, addressing it. Because at the end of the day, you are dealing with people and we are human beings who make mistakes. And you cannot, no matter how much you try, prevent that from happening. Human beings will always make mistakes, and that's fine for them to make mistakes. What's not fine is human beings making mistakes and you not being aware of them, because you might have an individual who is sending emails out to the wrong people once a week. Well, that needs to be addressed. Someone who does it once or maybe twice, maybe 3 times in their career, that's fine, but an individual who's consistently doing it needs to be spoken to and needs some training about how they check their email addresses before they send things out, or whatever it is the problem is. So yeah, actually having a very full data breach record, in my view, is the sign of a really good organization. It's not a sign of a bad organization, usually, depending on what the breaches are. But if they're low level, they absolutely should be recorded. We had a question about heightening or highlighting the importance of keeping documentation and records for UK GDPR compliance when there are so many other priorities for schools at the moment. And absolutely, we do understand that. Obviously, we specialise in data protection, so we will be telling you this is highly important, and it is important, and compliance with any regulator is important. And I think it's just one of those things that that just has to be put in the mix. And there are huge pressures on schools, particularly at the moment and with the pandemic. And so there is a bit of leeway, I think, with the ICO and a bit of understanding. But as we're coming out of the pandemic and things are going back to whatever the new normal is, the ICO is going to start to be a bit less willing to hear that as an excuse or as a reason for not being compliant, and is going to start being perhaps a bit more hard-nosed. So I think it's difficult to give actual, this is what you should do, because it's about your organisation and how you go about the individuals that are in your organisation as well, and how much they are on board with this. But actually, starting from the top down can be quite helpful. And as we said, speaking to your governors and making sure that they know that they're not just responsible for making sure the school's compliant, they're responsible for helping you to get that culture of compliance going. So maybe starting with the governors might be a tip.
Brilliant. There's a question about DPIAs and Class Dojo, which is an online platform that some schools use. I don't quite understand the question, so if you'd like to contact me, my mobile number is on the slide here to talk about it. But just kind of to talk about DPIAs and online platforms, it's brilliant that you're thinking about DPIAs in the context of using online platforms. I really wish more schools would, because it's really important, and DPIAs as a really good way of thinking about data protection compliance. Getting those essentials right, as I said, is so important, and really kind of building from the ground up. Using SCCs in relation to online platforms, yeah, I mean, technology companies will be using SCCs, so I'm waiting very much with bated breath, if I'm honest, for the UK SCCs and for the ICO's guidance on TREMS 2. It's going to be really interesting to see what approach they take, and if they take a different approach to Europe, that'd be interesting to see. The government are making quite practical noises at the moment around international transfers, but the ICO are independent from the government, so it'd be interesting to see what the ICO's take on this is. But if you've got any specific questions about overseas transfers, do give me a ring on my mobile. That's more than okay. And someone just pointed out that data breaches might have to be reported as a serious incident to the ESFA, and that's absolutely right. Some data breaches do need to be reported under charity law. You're absolutely right there.